I think Josh, you're probably who can share? Only host.
Yep, we can see.
Can you see my screen now rather than just me?
Yep, I can.
Great. How do I make that go away? Okay. So I'm just having some technical issues trying to get this up. Okay, so is that, Josh, can everyone see, well, can you see the slides in slide mode?
I can see it in full screen.
Great, I'm sure everyone else can too in that case. So I'll just start by introducing myself. So my name is Simon Davies. I trained as a lawyer in a big law firm before I wanted to kind of set up my own legal enterprise. So I was trying to sort of accelerate a program, set up Accelerate Law, which is a legal services business for startups. And it's supposed to be a bit less bureaucratic, a bit more, let's say, reasonable in various ways for startups. And then more recently, we've set up Legal Sidekick, which is more of an interactive automation and learning platform from a legal perspective. So some of the things we'll look at today, we'll use Legal Sidekick to illustrate a few points. So the idea is, if you're starting a business, you can either use the Legal Sidekick platform to create some of the documents you need and access information you need, and then where you need kind of that extra, let's say, specialized expertise, then you kind of you can come to someone like me to support you to fill in those gaps. So this today is supposed to be a workshop about basically taking you through the legal journey of your startup. So we'll look at that legal journey. We'll look at a checklist in quite a practical way, and then we'll look at kind of how you actually implement those things in Q&A along the way. So effectively, I've spelt out that a firm's legal journey is effectively this in summary. So you start by validating your idea, just making sure that it's something that can actually go ahead, and you're all in this workshop, so I feel like you're all more or less past that stage now, so you're going for it. Then you want to start your business, so registering your company, you got your company name, just getting the basics set up. So what we're going to do is we're going to go through each of these steps as part of this workshop. You build your team, so that might be, and you see the little car has got a bit bigger at this point. So you might have co-founders, you might be hiring freelancers, you might be even hiring an employee if you've raised funding at this point. You're building and protecting it, so you're building the technology or the physical product, whatever it is, and you're protecting it with your, let's say, your terms and conditions, your various contracts that you put in place, maybe your trademark as well. And at that point, you're ready to get out there and do business. I've put that you can stop up for investment along the way. That obviously depends on your finances, but that's obviously kind of an important aspect of building a let's say, a high growth startup. So the result here is that this is what I would say you should be aspiring for. So you'll have your strong foundations, so you've got your company registered, any shareholders that are part of your company, so co-founders or investors, their position is clear. Anyone that you are hiring, they have good contracts in place, you've got your terms and conditions, your policies on your product and all that kind of stuff, so you're operationally stable, and then the business that you're doing, all the deals that you're doing are strong, so you're not just signing contracts which people put in front of you, you're making sure that you're able to read a contract, which is, let me say that anyone in this workshop can read a contract and understand what's in there and negotiate certain points, that you don't need to be a lawyer to do that, even though it's good sometimes to have one. And then if not, you kind of just get stuck. You end up trying to solve problems that didn't need to be there in the first place. And I think what I'm saying is, if you use Legal Sidekick with our support, kind of as and when needed, it puts you in a very good position to get here. So So let's get going with the journey. So first step is we're talking about validating it. I'm going to go through this pretty quickly. So am I using someone else's intellectual property? Is someone else doing the exact same thing with the exact same name? That's an issue. Maybe you can change the name at some point. If that's the case, any regulatory approvals? Is it feasible? But hopefully, I think you should already be at that point. I'm also going to go through this part relatively quickly, which is to do with structuring your company. So, like, what are you actually going to register? Because I think a lot of you will have already registered a company, and if not, it's pretty straightforward process actually. And there's a guide on Legal Sidekick. How to register a company on Companies House. You just follow the steps to do that. But just as a broad overview of the options, so sole trader, so that's just someone starting and you're running your idea before you've actually registered anything, but equally you haven't made any revenue at that point. Limited liability partnership, that's more common for like law firms or professional services. And what you guys should or will have is a private limited company. You register it at Companies House, you follow the step-by-step guide on Legal Sidekick, and if it costs £12, should be pretty straightforward. Registration practicalities, 10,000 shares. I think if you follow the guide on legal, I'm trying to just rush through this part of it, but basically you register a company, you choose the number of shares that you've got. Let's say, so if it's 10,000 shares of 1p each, 1 penny each, then the total value when you register it is £100. And if you have, the reason I say 10,000 shares rather than say 100 shares is that when you want to issue 2.3% to an investor, you can do that with 10,000 shares. But if you've only got one share, you then have to split it out and it becomes more complicated. But yeah, follow the guide for that if you haven't already done it. Then we're looking at, I think the next step is about building your team. So if you have a co-founder or co-founders, this is obviously an important part because you need to make sure that your arrangements with each other are nailed down. So just don't know the best way to do this while everyone's on mute, but I probably won't do an exercise, but just while I'm going through it, think about the things. If you were starting a business with someone, just list out kind of at home on your, like on a notepad or on your laptop, wherever you are, just think about the things that you would want to have in place if you were starting a business with someone. And the main thing to take into consideration is that it isn't, let's say, a 2-year thing or a 1-year thing. It might be something for 5, 7, 10 years. So you have to think, what happens. The biggest considerations are what happens if the other person. Well, what happens if what happens if you want to leave? What happens to your shares if you want to leave? What should happen? What's fair? What's in the best interest of the company at that point? Also things like, what if someone's not fulfilling their obligations? What if someone suddenly says, actually, I can only commit half a day a month to this? What should happen in that situation? So you put a co-founder in place to protect the future of the company, because if you don't have that agreement, then it's possible that your future investors will question it. They might not question why you don't have one in place, but they'll want to know even when they're putting the investment in place, that there are some conditions on the holders of shares. So the main things that I'd be saying there are, the things to agree on. What happens if someone leaves? What are everyone's roles and responsibilities? What can people do with their shares? If there's a decision to be made, does that decision need to be unanimous? Do you both need to agree, or does one person have a casting vote of some sort? So I think there's all sorts of things to think about. Again, this is a contract with Legal Sidekick membership. You can create that for free, and the membership for you guys is 50% off. It's usually 29, but it's so $14.50. So I think the best thing on that is, if this is going to be something that you're wanting to use, then create that document and effectively kind of have a read through it so you can understand what's within, what's in there and what are the kind of things that people agree on. So the other aspect about building a team, especially in the early stages, is going to be about the people that are delivering services to you. So they may not be an employee, but it may be a freelancer that's delivering development services or design services or just giving you, or marketing services or whatever it is. And I think the key thing to confirm here is that when you're entering into any kind of service arrangement like that, is the biggest risk that you can have effectively is that your supplier is actually in control, is too much in control of the relationship, in that really what should happen is that they should be delivering an agreed scope of work after that, and after which you're confirming that you agreed that the work is complete, and then you pay the relevant fees. You don't want to be in a situation where you've paid, for example, too much up front, and then the supplier isn't incentivized enough to actually deliver what they've agreed to do. So there's I think the important thing here is to understand what the scope of your relationships are with your suppliers. So if you know that, for example, that you want to create a marketing campaign, and that needs to include some images, videos, copy, and various things, you want to make sure that all of that is included in the scope of work. And if possible, you should be agreeing, if you can, fixed fees for the agreed scope of work, rather than saying, well, we charge, they might say to you, we charge £1,000 per day, and you're thinking, right, well, so if you feel like you can spend an extra day on it, and it's going to cost me £1,000 more for the same result. So ideally, it's fixed fees within an agreed scope, and you pay those fees once they've delivered the agreed scope. And if for example, you also want to have something called acceptance testing, where they give you what they feel is complete, but then you have an opportunity to say, actually, no, that's not complete. We need to go through this feedback, and you need to fix it. So up until the point that you feel like they fixed it, you shouldn't be paying the full fees. It may be that you've paid a bit of a deposit, just out of fairness or out of reasonableness, because they need to feel that security too as the supplier. But the point is to maintain control of these relationships, and a part of it is also that you don't want to piss people off. You don't want to feel kind of like they're not motivated to work for you. So it is about striking a balance as well. But equally, you need to make sure you're not the person that's kind of an easy client for them. You need to make sure that you're getting exactly what you've asked for, and you shouldn't be afraid to be a bit, let's say, stern on these things. So this is, let's say at this point, so you've got your company registered, you're building your team. The next thing, we're looking at stopping off for some cash. So basically, most of the people in here, what you are able to do is you can apply for a startup loan, which is debt. You obviously have to repay that back, and the coronavirus, there have been schemes associated with that. But putting that to one side, the standard form of investment, when you talk about startups going out to raise investment, they're raising equity investments. So you're receiving cash in exchange for shares in your business. And the way we do that is, so we're looking at the left-hand side of this. So number one is the bold part. So equity from FFF, that's our friends, family, and fools on some occasions. Angel investors, incubators, venture capital. So investors in your business, they're giving you cash. In exchange for shares. So the process here, and this is an important, I suppose, reference point for when you reach that stage, is that the first thing you want to do is first thing to agree is the broad top level agreement. So how much money they're giving you in exchange for what percentage. And once you've got that agreed, I'd say that when you're talking to investors, the best thing to be able to do is to demonstrate that you're raising a specific amount of money to kind of cover a specific number of costs and take you through a specific period of time, and you therefore want them to provide a certain amount of money, and you kind of suggest a valuation to them. It's better to set out those terms yourself rather than just go to investors and say, well, I'm looking for some money and not being specific about it. And from there, you kind of show that you're in control from day one. You know what you're looking to do. So in terms of the actual process, once you've agreed those terms, so you would send them a term sheet. The term sheet is, again, something you can create on Legal Sidekick. There's a version on there. You send them the term sheet. You don't need them to sign it because that's just slowing up the process, basically. You want them to just kind of agree to the term sheet. If they have any comments, they can provide them, but nothing needs to be signed. And then once it's been agreed, you then send them the long form agreement, which is kind of in a lot more detail, covering all the different provisions about shares and who can. That agreement is split up into the first part, which is about the investment itself. So it will set out that X amount of money is being provided in exchange for, so let's say £100,000 is being provided in exchange for 111 shares, which broadly works out to about 10%. So it'll have those details, and then it will say things like, it will talk about the operations of the company. So who are the directors, who's running it, what are the general obligations on the directors, so how often do they need to meet, and there'll be various things like there'll be various protections for shareholders, for investors. So they may have certain matters which they need to approve. So before the company takes out a loan or borrows money, it may be that you need to go to the investors for consent for that, because the investors want to see that they need to know that their money is being used appropriately, but also that the company isn't being let's say they need to make sure it's running the right way, and there'll be some kind of basic levels of control there, and your job is to kind of negotiate not too many controls, just a minimum level. But broadly, once that, it's just those two documents, so the term sheet's agreed, then the long form agreement, and once that's signed, really what the process is, you send them the long form agreement, you say please sign and send us the money, and after that there's just a few bits of administration. So it's not actually, provided the investors aren't kind of going too deep into the negotiations, it's not actually too much of a complex process, provided that you've got the right level of support. Step 5 is about protecting your business. So, 1 second. So the main thing here is around. I suppose what I've got for you here is a snapshot of the British Airways footer of their website, and what you can see here is, although here there's kind of lots of different things which you don't, which kind of are more broad in scope than what you would need for a new startup. These are basically, from a legal perspective, these are the things that you want to put in place. So we've got legal, which is going to be so you've got legal, which is going to be your terms and conditions. So if you're producing an app, your terms and conditions are effectively the contract put in place for everyone that signs up or uses your app from the moment that they sign up to it. So effectively, there's a contract from the minute that they click accept on your terms and conditions. An important part of the terms and conditions is not only your contract with your customers, but it's also an important way of protecting your copyright and intellectual property. So if you, for example, have something in your terms and conditions which says, which confirms that everything on the site is your intellectual property and nobody has permission to use it for any other purpose other than using your product, then, for example, if you see that one of your competitors has, if you feel that one of your competitors or a new business has started using very similar things to you, and you can see that they've created an account on your product, that's a good position to be in, because you're in a strong position against your competitors saying that you've taken my intellectual property. So this is a thing that I think at least a lot of people through Hyper ask me, how can I protect my app? And the truth is that it's very rare that you'd be able to protect a software product through a patent, which is generally a protection over a form of invention. So generally, your options as a founder of a software business is effectively to use. So you might have a trademark, which we'll look at below. You see their little mark just under the British Airways All Rights Reserved sign. So that's they'll have a trademark over that logo. But really, if you're looking to protect the intellectual property, so it's your trademark, your contractual position, your T's and C's is a massive part of that. So when you're the IP section of your terms and conditions is important, and also what I didn't mention earlier, which I should have done, is when you're building your team, you should always have a contract in place with your freelancers, agencies, anyone working for you, at a minimum level, regardless of kind of how much you trust them, because that should confirm that the intellectual property and all of the work that they're creating belongs to you, or belongs to your business. So unfortunately, the bad news is that you can't generally, as a general rule, you won't be able to kind of protect you can't file a patent for your particular, for your piece of software for your, for exactly what you've created, but you can still take steps to protect it through your contractual position, in addition to your trademarks. And I think the thing there is that for some people that feels uncomfortable, but I think the thing you have to remember is that it's very difficult to create the kind of things that you're creating. It takes a lot of, as you know. So it's not simply a case that someone can just go on there and copy absolutely everything. The reality is that if you've produced something fantastic, people, there will be competitors, but I think you just have to kind of keep on going with it, essentially, and making sure that you're able to be distinct from them. The other thing that you'll see here is the privacy policy. So this is all about GDPR. So you will have heard about GDPR. You'll have received lots of emails about it from companies that you're signed up with. I just realised I wonder if there's if anyone's typed anything in the chat. I haven't seen that. Let me just see here. I'll look at the chat after I've looked at this slide. So your privacy policy. So from a GDPR perspective, you'll be fulfilling your obligations, provided that you have a privacy policy in place, and that you have a tick box when people are signing up for your product, saying whether or not they agree to receive marketing communications. So the two things from a GDPR perspective early on, at least from a legal perspective, is that you want to have your privacy policy on your website. Again, that's something you can create on Legal Sidekick, which will be a customized document for you on there. You'll have that on your platform. People will agree to it. The privacy policy is effectively part of your terms and conditions. So the privacy policy says something in there which says we are agreeing to. The privacy policy has something in there which says these form part of the terms and conditions. So when you click on the box to sign up to the product, you're also agreeing to the privacy policy. You have the tick box for marketing communications. I think the important thing to note is that once you have those two things in place, after that, it's more a technical thing to make sure that you're not sharing people's data without their consent, which effectively you can't do at this point. But it's also a case of just making sure that your systems are secure, and that's more of a technical question. But from a legal perspective, you don't need to be let's say, I think a lot of people get quite worried about GDPR, but I think those are the things that you need to ultimately have in place. What you can do, and what I think people go over the top with is, you are still, if people have signed up with you, you are still able to contact them without there are circumstances where you're able to contact them without their permission. So, for example, if someone signed up with you and you've released a new product feature which you think is going to be really useful for those people, they've signed up with you, and it's within your reasonable expectations that they would be willing to receive that communication. I think, especially at the early stages of a business, you shouldn't be letting kind of fears over GDPR and, let's say, lack of knowledge over it, dictate that you can't contact the people that have signed up with you, which initially may not be that many. So I think it's important to note that you can't be too cautious there if you're starting a business at this stage. If you're not sure about that, let me know. But I usually take it, at this stage, you should be taking, I think, not overly cautious approach, frankly, when it comes to contacting people. And then the final part is in the footer, so the trademark. So generally what you'll be looking to trademark as founder of a new business is, generally it will be your business name. And I think the key thing to do, really, a trademark is, registering it as a process in and of itself. But I think the key thing to do before you absolutely finalize your name is to go on the UK trademark website. You can just do a Google search for trademark search UK and do a search on there, and do a search on there for what for your company name, and you can see there on there that what companies already exist using your business name. So ideally you won't see anything there, but there may be companies which are using your name in a, let's say, non-competitive sense. So, for example, if you have a business name and you're selling software, whereas someone is doing has exactly the same business name but is running a restaurant, that's not going to be an issue because they're in different, what are called different trademark classes. Whereas if you see someone using your exact business name doing something very similar to you, there's a good chance that they would oppose your trademark application, which means that you probably don't want to start investing too much in kind of building out your brand using that name, because there's a good chance that you may need to change it. So before you settle on a name, you want to kind of have a look at the trademark register and do that search to make sure that there aren't any massive risks. So, for example, if a massive company is using your brand name as a kind of sub-brand of their brand, you're not going to want to get into a legal battle with a massive company that you'll never win. So that's definitely something to check, and that's on the Intellectual Property Office website. You can find that kind of quite easily through Google. I've got a question from Amar here. So, the question is, what are the minimum legal actions preparations that you recommend for an early retail consumer tech startup? A list and timeline to the stage would be very useful. So for an early retail consumer tech startup, so I mean, I'd say that if I just go through, I'm trying to think of it, kind of what are the differences for a retail consumer tech startup as opposed to kind of all of this general to-do list that we're looking at. What are going to be the differences there? I think, I mean, in your case, and really for any startup, I think the steps that we're looking at here are fairly general, and actually it'll just be a case of for any of your startups, so obviously validating the idea, starting the company, this is true for any startup, building your team, again true for any startup, cash, again true for any startup, protecting it, again true for any startup. I think actually up to this stage, this is where the kind of this advice is quite standardized. And this is why, for example, Legal Sidekick, this is one of the reasons we were able to make it, because a lot of these things are a bit more standardized across all startups. They're not as customized. I think in the case of a consumer retail startup like yours, Amar, I think the things obviously to be thinking about are the different, and actually what we'll look at here is probably the key part. So step 6 is when we're actually starting to do business. I think the key thing is to think, right, who are the key players in your organization? Who are the key relationships with? So in a case where it's retail consumers, so connecting consumers and retailers, you'll have your retailers, you'll have your consumers, and then you have yourself. So from a top-level legal perspective, the first thing you'll have to do is, well, at this stage, so step 5 is the T's and C's, which I know you know about, Amar, and those should cover effectively your relationship with consumers, your relationship with retail, but also if you're connecting consumers and retail, it's an important aspect of your T's and C's to cover that there isn't a contractual that you are not a party to the contractual relationship that is formed between the two parties that you're connecting. So if you're connecting retail and consumers, there's going to be a separate contract which is formed when the consumer goes to the retail, and you need to make sure that you are not liable or responsible for that. So if someone goes to a restaurant, the restaurant just as an example, the restaurant gives that person food poisoning, you need to make sure that your terms and conditions clearly cover that you are not responsible for the restaurant's obligations. Those are obligations to the consumer, and they exist between them, and any conflict between them should be handled separately. So it's very important to draw that distinction. So one more, we said, so Amar, if you have any more questions, let me know, and I'm going to look at commercial partnerships next. But just one more here. So from an anonymous attendee, can I only do trademarks for the country I'm running the startup, or I need to include other countries? So unless you're actually operating in that country, your trademark is effectively up for dispute. So when you register a trademark, you need to actually demonstrate that you are using the trademark. So that's the first point. The second point is it would be quite an expensive operation to start registering trademarks in territories which you aren't using, because it can be an expensive thing. So generally with a trademark, the sensible thing is to kind of build your way up. So you start with the country that you're operating in, and then if you're looking to operate in more countries, you can register there. I think the question that people often have is, should I do an EU trademark or should I do a UK trademark? Now those are going to be different things as of the end of this year. So the question will often be, I think the one thing to bear in mind is if you're operating in the UK and let's say France, you then be able to do an EU trademark because you're operating in an EU country. But if you, for example, were saying I'm operating in the UK and maybe in a couple of years I'm looking to go to the US, it wouldn't be a common or a smart kind of budgetary choice to start registering a trademark in the US unless you really felt there was kind of a desperate need to do that. Okay, so I'm going to scroll through to step 6, which is about commercial partnerships. So, I mean, this is where we start to get a little bit less standardized. So I think out of everything we've looked at, most of it is pretty, can be fairly standardized across all startups. The one thing that probably isn't is your terms and conditions, because naturally those are very specific to your particular startup and the relationships that you're forming with your customers or members or users or whatever you're calling them. Let's see. My slides are frozen, so I'm just trying to. There we go. Okay, so the next step here is about doing business. So I'm just going to kind of recap just to kind of drill it home. So validate, register, build your team, contract with people working with you, get the investment, your terms and conditions, privacy policy, trademark. So, your basic protections are in place. And this is the point, the last step, ready to do business. So obviously doing business for different companies looks different. But one thing I wanted to pick out here was, and something I think we may be having another workshop on in the near future, is commercial partnerships. So I find that commercial partnerships is a very useful way of reaching a new market or spreading the word about your business without, let's say, expensive marketing, or kind of which people often say is a bit of a black hole with certain types of marketing. You don't really know where it's going and it's not clear. Whereas with a commercial partnership, you can identify a clear, well, we'll look at it here, but effectively it's all about finding a complementary business to yours with a common customer. So what you're trying to find is, and when I say complementary, I mean a non-competitive business. So naturally, you couldn't form a commercial partnership with a competing business, even though you have the same customer. But there are lots of businesses which will have the same customer as you, but for a slightly different service. So what you want to find is those businesses, like what are those complementary businesses, what categories are they in, how do you find them, and what are the terms that you put in place. So just looking at an example here. So your business, in this example, is a subscription bottled water company. So let's say you're delivering bottled water to people once a month. It's super heavy if you go to the supermarket, so they're going to have it delivered to you at home instead, which saves you all that time and hassle. Probably not very, probably a bad example at the moment because it's probably not great for the environment. But let's say it was a subscription bottled water with non-plastic bottles, let's say. So complementary business for that, really, what we're potentially saying is, okay, so we've got a vitamin company, a common customer is a health conscious consumer. So that's what we're probably saying is, if you're a subscription bottled water company, your consumer is health conscious, so and so, X years, 28 years old, lives within XYZ of wherever. So you build that customer profile, and then you're saying which other companies are also targeting that profile. So I've said here, a vitamin company is also targeting them. So and in both cases, so what we're setting out here is, okay, so those are the relevant parties, but what are the relationships between those parties? So between the subscription bottled water and the consumer, so they're getting monthly bottled water in exchange for money. Same with the vitamin company, over-the-counter vitamins in exchange for money. So the question is here, what is therefore going to go between, and this is often the complicated part, what's going to go between your company and the vitamin company? What does the cooperation look like? How can you help each other reach this common customer? So some ideas here might be, vouchers in the subscription boxes, so vouchers for vitamins in the subscription boxes, marketing for the vitamin company in the subscription boxes. But equally, the vitamin company might say, well, if I'm putting vouchers in your subscription boxes, I'm giving you value. So that's kind of adding to the reason why someone might purchase the subscription bottled water. So from their perspective, they're saying, okay, I'm adding value to what you're offering. Whereas from the subscription bottled water business, they're saying, well, no, I'm giving you marketing to all of our customers. So the question is here, which direction does the money go in? And in this case, you might say, well, there's no money involved because we're helping each other. So it may be that and a lot of that will depend on, let's say, the gravitas and stage of the various of the different parties. Like if one party is huge, one party is new, it might be there's a different bargaining position. But I think this is the kind of model that you can be looking to build with your different commercial partners and seeing, how many of these can you build? And the more you build, in theory, the broader your marketing is without without the traditional marketing costs. From a contractual perspective, there's a commercial partnership agreement on Legal Sidekick, and it would just be a case of kind of adapting for your particular partnership. So those are the steps. I think if you basically kind of follow that through, you'll build a secure, strong startup, at least from a legal perspective, and all being well, you're doing good business too. And then the question is, so we've kind of alluded to it, but how can you actually put that in place? So from a leading a business perspective, what are the right choices to make? How can you make them in a kind of way which balances risk and cost in the right way? So risk is that you're going to make mistakes or not do it at all, and so that's legal risk. Cost is that everyone knows that law firms are big, expensive companies. You may not want to or may not have the budget for that, and even if you did, it might not be budget well spent. So from a legal perspective, generally what I say is every relationship that you have is documented by a contract of some sort. So whether it's with staff, suppliers, customers, partners, shareholders, there's always a contract in place there, and that contract is there to establish people's responsibilities and obligations, but it sets out kind of legal framework. So all of these contracts will cover something to do with intellectual property. All of these contracts will cover something to do with each party's obligations, what they have to do if they don't do it, or if they do something terribly wrong, what's the consequence? And that's the case with everything we've looked at. The common feature is that there is always a contract in place. So with teams, investors, shareholders, commercial partners, etc. So, and I think the question is, what are the different ways of doing it? So one way is saying pure DIY. You search for a template on Google, you find it. Naturally, I don't think this is a great approach, because I think you don't know where it's necessarily coming from. It may be tailored to other needs. It may be you, and then the only time that people look at contracts is when you're looking at quite specific clauses. So it's important to know what's in there and have it customized for you. So on the other side, you can get professional advice for it. So My Business Accelerate Law is a version of that. There are obviously many versions of that, which is just kind of your law firms. So if you went to the biggest law firms around, you would be paying an absolute fortune. It would not be suitable for you, kind of be crazy at this stage. So we set up Accelerate Law to give an option for people to get professional advice at a more startup appropriate, let's say, cost, but also just level of service, kind of more one-to-one, less bureaucratic. But in the middle of that, kind of what I think now is a very good risk cost option for you guys is what we've done with Legal Sidekick. So this is a good combination between kind of taking a slightly more DIY approach, but also having kind of a level of professional support with it. So it's kind of like a supervised DIY approach. So basically, you can go on there, create a contract, and then I or one of our team can review it for you, or add different parts to it for you, kind of adapt it for your particular business, but naturally less time involved as kind of, because you're basically, when we talk about a standardized approach, what we're saying is you're benefiting from the experiences of many others who have come before you. Which is nice, because it's effectively cooperative, and it means that you've got that kind of cooperative aspect, and then you customize it on top for your very specific elements. So what I'm going to do is I'm just going to go on. I think I'll just go to Legal Sidekick very quickly, so you can have a quick look at it. Let me just double check this on. So I'm just going to share a different screen. So I think some of you will have already created an account. I think the registration aspect is, there's a slight bug on it at the moment. So if you do want to create an account after this workshop, just send me an email. You can and I'll set you up, and you can have a look through. Let me see here. So I'm just going to share a new screen. So this is on Legal Sidekick. So you can basically search for any of the documents you want. You don't need to be logged in. So if we wanted to search for, let's say, trying to think of one, consultancy agreement. So if we search for that, that should come up shortly. So you can basically search for the documents you want. Actually, not sure about what's gonna. So this is the that's a bit slow at the moment. Okay, so if you search for that, you can kind of see some guides on it. So about consultancy agreements. If you want to then create the consultancy agreement, you would click on here. Once you're actually inside the platform, it looks a bit different, but it's probably got, I just want to make sure, it's actually got some preloaded details here. So hopefully those are just model details rather than, I think it will be. Let me just double check. Yeah, this is just a model one. These are our details. That's my dad's name down there. So you just kind of fill in the details. Freelancer's name that's my dad's name. It's got a funny middle name. And then we say, we answer the different questions based on what you're doing. And once you've done that, you can generate the contract. So what we basically charge is £50 per contract. If you were a member, it would be £40 because it's 20% off. And then if you want us to, and we can kind of do this either way, but you can pay an extra cost to basically kind of go through the document with us, add that kind of extra review element, make sure it's customized for what you need. And then you go through the payment option from there. And I think because I'm a member, it's reduced my cost to 40 rather than 50. So I think one thing that I think is worthwhile to have a look at, even before you're ready to put in any contracts, and something I've kind of put in place for more of an educational purpose as well as just kind of general project management, is the checklists. So if you go on here, if you create an account on here, what you can effectively do is work through and this is basically the same framework as what we've just looked at. So you can work through your checklist based on the different steps that we've looked at. So starting your company, building your product, building your team, shares, so that's share options, trademarks, IP, funding, so all these things. And what you can do here is effectively, you can go on each one. There's guidance on, so if you click on more, that takes the guidance article. If you click on get a template, you can get the template contract for a co-founder agreement, for example. And if you want to do it like that, then you can kind of click done or not done, etc., etc. And basically what is on here is there's a lot of free information, which I hope you'll find useful. So lots of articles, guides on there. If you ever have a question, what you can always do is search on there as almost a replacement for your Google search. And then if you kind of can't find the answer or if you clarification, you can reach out to me. If you're a member, I'm always more inclined to support, because obviously I have to run a commercial operation. But it's hopefully it's a useful tool for everyone here to kind of not have legal being one of these terrible, stressful, expensive and just problem areas for your business. I think the point is it's supposed to be simple and manageable, and something that you can kind of make as a useful part of your startup. So if you can't create an account already, just send me an email and I'll set you up on that. So I'm just going back to the slides. So what you've got here is, and I'll send this around by email as well, but Hyperlaw 4 is your code for your code for your 50% discount. So that will get you 50% off the membership. And with that, you get your co-founder agreement, commercial partnership agreement, a few others, discounts on other things. And I suppose I'm more likely to, if you send me a question, I can respond to it, because you're a member of our our community on our platform. And these are the emails. I'm quite informal and flexible, so don't be shy. Feel free to email me. Both of these will come straight to me. Does anyone have any questions? Right, we've got kind of 5-10 minutes to go. I'm just gonna, I suppose it's on mute. Let me just open this out. Okay, no questions in the chat. So there we go. So for friends, family, and fools around, do you suggest a standard agreement approach? So good. That's a very good question. I think I've done it in two ways in the past. I've said, a friend, well, let's say an acquaintance, came to me and said, I've got someone that's looking to invest £5,000 in my business to get me up and running, and I said to them, you just don't need a full agreement for that. So we just did kind of a 2-page summary, effectively saying you're giving this money in exchange for these shares. You have to, we just basically summarized a selection of the rules, and that's for something like that, I'd recommend that. However, if you're doing an FFF round, which is a substantial amount with different people involved, and you potentially want to add new investors later who aren't your friends or family, for example, then I do suggest you have a standard agreement, because it means that basically when you've run an investment round, you have your full agreement. In order to add an investor later, all you have to do is have them basically sign what's called a deed of adherence, which is basically a 1-page document. They basically sign up to it, and it says, okay, now I'm a party to the shareholders agreement. If you don't have that document in place, then you can't add people to it. So it's probably better to just have something in place, kind of standard form, sooner rather than later, because otherwise what you'll find is it's much harder for someone to negotiate a pre-existing agreement. So if that makes sense, you'd rather kind of have a standard agreement in place with the friends, family, fools, provided it's kind of a substantial enough amount, as in worthwhile putting in place, and then just adding people later, rather than having to negotiate it with those new people as and when they come in. If you need more information on that, Andrew, just feel free to be in touch. So Godfrey said, is the membership price you mentioned a one-off fee or a monthly fee? So that is a monthly fee, so it would be $14.50 a month. Yeah. So Andrew says, what about the agile funding concept? So if I raise money from FFF at different times over the next 1 year, for example, yeah. So what you can do is basically, I've done this a few times, say in your documents, you would say you're investing now as part of the first closing of an agile funding round, and within the next 12 months we're entitled to raise up to a maximum of £100,000 from various investors over the next 12 months on no worse terms or no better terms than what you've been offered. So basically it means that you can kind of continue the funding round, but have different, people providing money at different points in the process. And that's something that we would just have to adapt your documents to say that it's an agile round and that the investors agree to it. Because otherwise, the only difference is that usually if someone's invested, they have a right to then invest in every round that you do. So it's not that different to like just having one round and then another round. That's kind of it's more okay, but the main difference is that there aren't this right for existing investors to participate again. So, and just to confirm on that, I think that probably needs a bit of elaboration. So it's called, this is a right of shareholders called preemption rights, which is where it's a form of anti-dilution right. But for this situation, we'd like to have the valuation fixed over that anyway. So yes, you would have the valuation fixed, correct. So it's effectively saying we're going to have a fixed valuation for the next 12 months. Anyone can invest up to a pre-agreed investment cap. So you might say the valuation is X. Anyone who's investing up to the agreed cap can invest at that valuation within the next 12 months, and kind of no one can stop us, and we can use the same document. Okay. Tolu, sorry if I've not pronounced that right. Tolu is asking, how does dilution work legally when working with co-founders or current investors? So dilution occurs when you issue new shares. So there are rules that you'll have in your shareholders agreement, but there are also rules which exist under UK company law. So this concept of preemption rights is something that's just worth doing a bit of research on. Preemption rights are there to prevent unfair dilution, so they stop people just like issuing 1 million shares to themselves, because the rule is if you're issuing 1 million shares to yourself, you also have to offer those shares proportionately to all the existing shareholders. So, for example, and this is a protection for investors to stop them being diluted unfairly. So basically, if you have a company where you have 2 co-founders, 50 shares each, and then an investor has 10 shares, the 2 co-founders can't then suddenly say, right, we're going to issue 100 shares to ourselves so that proportionately the investor has less, because the investor has basically a right. If they're issuing 100 shares and the investor holds 10%, the investor has a right to 10% of those shares on the same terms which are being offered. So if those shares are being basically offered for free, you have to give 10% of those shares to the investor, and the maths works out that the investor is then not actually diluted. So what it means is that if, for example, you've raised from one investor and then in future you're doing another funding round, the investor has a right to participate in that funding round at the same, so that they're not diluted, but they'd still have to pay the same amount that the new investors are paying. So it doesn't stop you doing funding rounds, but it means that the existing investors, should they wish to, they can also invest in the future rounds at the agreed valuation at the time. So basically, I mean, it's a fairly complex area, to be honest, but the main things to look at: preemption rights, it's a right of first refusal on issues of new shares, and the general rule is, there are rules in place to stop people issuing shares unfairly, and it's just it's not something that companies can just do. There are rules there are provisions to guard against that, because otherwise everyone would do it. Any more questions? Any more questions from anyone? It can be kind of specific to what we talked about, or just general questions. If you feel like there's a value, there's one in the Q&A. Sorry. So the Zoom chat and the Q&A is a different thing, right? Okay, so Foppe has said, what's the liability you have on the contracts created up to what level? So what's the liability you have on the contracts created up to? I don't actually understand the question. Can you rephrase that, please, Foppe? So I'll talk through. I think the general principle of liability in contracts generally is that, and what you tend to see is liability is capped. Thanks, Andrew. So I think we've got basically 2 more minutes, but so just go through these last questions. So basically, commercial contracts, commercial partnerships. So the liability tends to be capped the amount that is being paid, that is payable within the last 12 months. That's a standard liability cap. However, for certain things where it wouldn't be reasonable to cap it there, like if the fees paid are £100, but there's a lot of risk, you could cap it at, say, insurance levels for certain types of things. So, for example, where there's something which is just completely out of your control. So, for example, if you have a partnership with someone, and then you get in trouble for using their logo from a third party who says that logo breaches their intellectual property, then really there shouldn't really be a cap on that type of liability, because basically it's completely in one party's control. So where something is completely out of your control, liability should not actually be capped. Each person should be responsible for their own responsibilities. But if it's in respect to a service being given, then usually it's the amounts paid or payable in the previous 12 months. And then Zafir said, what are the limits for fundraising rounds? So there's no limit on how much you can raise. What you can do, and an important thing to generally have in place if you're raising from UK investors, is to apply for SCIS and EIS assurance from HMRC. I know we haven't talked about that. I think we'll talk about that in a fundraising workshop, which is, I think, coming up, and maybe the next one at the end of this month or the next month. But there's no limit on the amount you can raise. However, if you're raising under SCIS, which is a very tax efficient scheme for investors to invest in startups, and part of the job that our businesses do, Legal Psychic and Accelerator, is help you apply for those confirmations from HMRC. The limit for SCIS is £150,000, but for EIS, I think it's like £5 million per year. So that generally won't be relevant. But no limits. Just depends what you can agree with potential investors. So I think the end of the allotted time here. So thanks. So great. So the fundraising workshop, that's very helpful, is on the 27th of October at 6 p.m. And you'll all receive an update for that. Great. And Zafir, thank you very much for that. I appreciate it. Appreciate your appreciation. Yeah, listen, I hope it was useful. Look forward to speaking with you, albeit with everyone on mute at the other end of the computer screen. For now, I look forward to the next workshops. You've got my details if you want to be in touch with me. Hopefully Legal Psychic will be useful for you. It's still, listen, it's still a fairly new product, so any thoughts or ideas or things you have on it, always appreciated. But if it's a useful product for you, all the contracts are there. Hopefully, I've prepared them. I can vouch for them. And good luck with all of your startups until the next time, and we'll see you next time. Okay. Great. So I'm going to shut it down now. Thanks everyone for joining. And I'll let everyone duck out. If there's anyone that has any final questions, now's your chance. But otherwise, you can be in touch with me. Okay. Thanks everyone.